So hello everyone, and welcome. My name is Timothy Scott, or TJ Scott. I'm an estate planning attorney, and I'm the owner of the law office of Timothy J. Scott. And let me tell you, I am so happy to have you here with me today. We're going to be talking about something that I know is a difficult topic. We are all going to die someday. And I know that that is tough to hear. It's tough to say, and it's tough to think about what my family is going to look like without me here. It's tough to think about the fact that we may become incapacitated before we die. And even though it's difficult to think about these things and it's difficult to contemplate what that might mean for our family and what that might mean for the people that we love, it's fantastic to have you here because it means that you're planning ahead. And it is something that we can plan for. It's something that we can have certainty about. And this is the first step, is being here with me tonight and getting the information, because I really believe knowledge is power. And that's what I want to do tonight. I want to empower you. I want to educate you. And I want to give you some peace of mind around this topic about exactly what happens at the end of a person's life. What happens if somebody becomes incapacitated? So I have a lot of really valuable information that I want to share with you here tonight. And I have some valuable offers that I'm going to be sharing at the end of the presentation as well. So I hope that you'll stick around for those. All right, let's dive in. The best way to learn tonight, with all of the information that I'm going to be sharing, and it is a lot of information, it can be a little overwhelming. The best way to learn tonight is to turn off the distractions. If you have another tab open, if you have something else that you are kind of splitting your attention between, if you have the game on, I don't know if there's any games tonight, but if you are trying to split your attention, it's going to be hard to learn this information. And so I really encourage you, you've given yourself this time, you've set this time aside, give yourself this time to be here and learn this information. And I always say your future self is going to thank your current self that you gave yourself this time. And if you stick around until the end, I have some fantastic offers that I want to make you. The first one is a free virtual one-on-one meeting where we can talk about the things you have and the people that you love and how exactly you can protect them. Plus, I have a bonus gift because I want to make it even easier to get a custom tailored estate plan written for the people that you love, and just stick around because I think you're going to like that offer. Okay, first, I'm curious what it looks like here. Do you have an estate plan? And so I'm going to post a poll. I have the capability to do that. Questionable a little bit, but it looks like a poll went up there. So, so the question is, do you have an estate plan? And I have listed here some elements of an estate plan, some parts of an estate plan. So trust is often an integral part to an estate plan. A will, a lot of people know that a will is a really common part of an estate plan. Guardianship nominations are extremely important if you have minor kids, that you get to dictate who is going to raise those kids until the age of 18. Let me tell you, a judge who only sees that person in front of them for maybe 2 hours over the course of 6 months is not going to know the best person to raise that child. You, the parent, are going to know exactly who the best person is to raise your kids. Healthcare directive, power of attorney are essential parts of an estate plan as well, as are beneficiary designations. Even though that's not something that an attorney typically writes, it is an extremely important part of your estate plan working the way that you want it to work. And I am seeing kind of an abundance of no, although it does look like there are some people who do have an estate plan in place. So most people don't have an estate plan in place. A few do, but I can promise you this information that I'm going to be giving you tonight is going to be useful for everyone. And so let me ask, if you don't have an estate plan in place, do any of these reasons resonate with you? And maybe you feel like you're too busy, and I completely get that. As a father of 3 with 1 on the way, life today is really, really busy. And I completely get that, but I also want to commend you for being here with me tonight and giving your time to learn about this topic and really explore it more. You're on the first step to getting an estate plan done. And so kudos to you. If you've been too busy in the past, now is a good time to jump in and get this taken care of. And maybe you feel like you're too young. And I see some people saying, yeah, I'm too young to have an estate plan. but really anyone over the age of 18 should have some estate plan in place. I recently helped a young family, and a young father had passed away and left something of a mess for his wife and minor daughters. But that doesn't have to be the case. You can get an estate plan in place. It doesn't have to run you an arm and a leg. And I'm seeing a lot of people are saying estate planning is too expensive. And I'm going to be sure to address that tonight. I'm going to talk about tonight exactly what estate planning should cost you and what you can expect to pay for it. And I can tell you, people can be pretty flexible in when they care, and they want to make sure that you have a great estate plan in place. And maybe you're worried about jinxing yourself, and nobody's even willing to put that they're worried about jinxing themselves, because that's how worried they are about jinxing themselves. And that's okay. But I can tell you, I have heard this from a lot of people, and I have never seen a correlation between somebody getting an estate plan done and having something happen to that person. And I always say, my clients, people who get an estate plan done, seem to live more intentionally. They live with more intention and less of a burden on their shoulders. And so, from my experience, they are less likely to jinx themselves. It makes their life more fulfilling when they don't have this monkey on their back anymore. So, thanks for responding to the poll questions here too. All right. So, if you have a plan in place, or if you don't have a plan in place, but one of these resonates with you, I hope that you'll let me know that. I'm going to answer all of these questions tonight. These are all really fantastic questions, and they're all probably something that has crossed your mind or something that you're curious about. Maybe you want to know if an online will is enough to protect you. Maybe you want to know if that online will is going to take care of your family the way that you want them to be taken care of if something happens to you. Maybe you wrote a plan, or you had an estate planning attorney write a plan 10 years ago or 6 years ago, and you want to know if that outdated plan is okay or if it needs to be updated. There are a lot of changes that happen in the law. There are a lot of changes that happen in our families. And so knowing what kind of changes have occurred and knowing what kind of changes might affect your estate plan, I might be able to give you a better answer to that tonight. And maybe you just want to better understand your plan. And I completely understand that. A lot of estate planning attorneys will kind of guide you through on rails and won't completely explain the plan that they've written for you, or have you really determine what's in your plan. And that's something that I want to fix here tonight. Again, I am really big on educating people because I want them to know. I want them to know exactly what's in their plan. And in fact, I want them to have the power to write that plan or to express their wishes in a way that I can capture, so that they know exactly what's in their plan. And if you have a specific question, again, I hope that you'll post either in the chat or in the Q&A box so that I can see those questions come through, because I'd really love to answer them tonight. I want you to know that you're in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online or fill in the blank will, and you're just not sure if that document that you prepared is actually going to take care of the people that you love. And you're in the right place if you're nervous about how much this is going to cost. I completely understand that. I completely understand, as a father of young kids, being sensitive to costs and expenses. And I can tell you, I'm going to speak directly to that point and tell you exactly what you can expect to pay for an estate plan tonight. So stick with me here. Whatever the case is, wherever you're coming from, I want you to know that you're in the right place. And I am really excited to educate you and empower you tonight on this topic. The reality is, estate planning isn't about us. And this was something that kind of occurred to my wife and I recently when we were updating our estate plans. These are my three kids, by the way. From left to right, it's Margaret, Ben, and Elizabeth. And Margaret is now 4, Ben is 9, and Elizabeth just turned 7. And those kids are my whole world. But it occurred to my wife and I that the estate plan that we were writing was never going to enrich us. It was never going to bring us wealth. It was all about protecting the people that we love, those three kids, and making sure that they were well taken care of if something happened to my wife and I, that they had somebody that they could go to, that they had assets that they could pull from, that those assets weren't going to do more damage than good, which I know is a concern for a lot of parents who have money going to kids of all ages, really, that might not be able to handle those assets. So the reality is your loved ones are going to know whether you lived up to your promise to take care of it after you're gone. And I promise you, it is simple to take care of. It is simple to work with an estate planning attorney, and it's simple to have it taken care of. So here's what we're going to talk about tonight. We're going to talk about planning for incapacity, and that includes things like who can make healthcare decisions or who can make financial decisions for you. For example, if you're in a coma, or if you're nearing the end of your life, who can make those decisions for you if you're suffering from dementia or Alzheimer's. Also, we're going to talk about planning for when you pass away. If you have minor kids, that means guardianship, making sure that the kids have someone who can raise them until the age of 18, making sure that that's legally documented so that it's really clear exactly who you want to take the kids, and that a judge isn't going to be making that decision for you. We're going to talk about a court process called probate. And probate is, like I say, a court process. It sounds crazy, but probate is a process that most of us have to go through. If you don't have an estate plan in place, you are opting to go into probate. And if you only have a will in place, you are also opting to go through probate. But probate is optional. There are ways to avoid it. And I'm going to talk about that tonight and the exact ways that you can avoid probate. We're also going to be talking about estate taxes tonight. And there, at least, I have some really good news for everybody, because estate taxes don't apply to the great majority of people. In Minnesota, we have a lower estate tax exemption, and I'll talk about that and when you might have that estate tax applying towards your estate. I'm also going to talk about unclaimed property. I'm going to talk about intangible assets, things like stories and values, and how you can share those with the people that you love. So it's a lot to go through tonight. That's why it's going to take the full hour. And again, I really hope that you'll stick with me here. Before I jump into it, let me just tell you a little bit about me and who I am and where I come from. So this is my family, and we live in Bloomington, Minnesota. My wife's name is Tobin, and this time from left to right, the kids are Elizabeth, Margaret, and Ben. And I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, Ben, was born. So there you can see May 12th. That's me. Is the word matriculating? I think that's the word. And May 13th, that's me holding my son for the first time. After law school, I found a job with a small estate planning and tax preparation law firm in Minneapolis, and I loved the clients that I was able to work with. At the same time, I didn't always feel like I was providing the value that I thought my clients deserved. So a little after 3 years with the firm, I ended up leaving, and this is actually a picture of my last day there. Someone has to graduate at the bottom of the class. Now, I have to say, this was not said about me, but this was something that my mom actually said about an estate planning attorney who helped my grandmother before she passed away. I remember my mom saying this: someone has to graduate at the bottom of the class. And her frustration was so visceral at that point, having this experience of working with this estate planning attorney and ending up in probate and all of the issues and drama and everything that ensued. But in reality, I don't think that this estate planning attorney probably graduated at the bottom of their class. I think that it wasn't an issue with this attorney's knowledge. I think it was an issue of the model that he was practicing under. It was a very traditional model of estate planning. I call it planning for death, and we'll talk about that later. But first, let's talk about some of the aspects of estate planning. So we're not going to have polls all night, I promise, but I do have one more poll that I want to post really quickly. If you would answer this demographics question, just so I kind of know what the mix is here with us tonight. I'm seeing some a lot of people with young kids tonight, some single, some married with grown kids. Guardianship, when you're talking about guardianship, you're most often talking about people with minor kids. There are other situations where guardianship comes in if there's somebody with special needs, something like that. But most often when you're talking about guardianship, you're talking about people with minor kids. And I see that there are a number of people with minor kids tonight. So I am going to go ahead and talk about this topic a little bit. If this doesn't apply to you, that's great, but it might be information that you want to share with somebody that you love as well. So when you're talking about guardianship, there are a couple types of guardianship that you might be talking about. Short-term guardianship or immediate guardianship is something that I think is really important and isn't addressed by most estate planning attorneys out in the field. It's just not something that is on most attorneys' minds, but it's really important. If you have a babysitter and there's no plan in place, and for whatever reason, you and your spouse or you don't come home from date night, and the police are called by that babysitter, which is going to happen eventually when you don't show up at 2 a.m. or 3 a.m. or whatever the time is, Child Protective Services is probably going to get involved with your kids. If there's no plan in place, the police don't know who those kids can legally stay with. The babysitter is not going to probably be an option, either because of the age or because they're not a related person. And at that point, Child Protective Services might get called in and the kids may have to spend some time over there. And this isn't to dig on Child Protective Services. I think that they're doing the best job that they can with limited resources and limited means, but it's not where I want my kids to have to spend any time at all. And so it is really important to plan for that short-term guardianship if something were to happen to you and happen to your partner, so that the kids are covered, so they have a place to go, and there's legal documentation that says this person is able to take and stay with my kids. So that's one side of the coin. The other side of the coin is long-term guardianship. And most estate planning attorneys cover this for people planning if they have minor kids. And the truth is, if you don't have a plan in place, there actually is a plan that's written for you. And the state of Minnesota has written plans dealing with a lot of the topics that we're going to talk about tonight. And often that plan is a judge is going to decide. And that's the plan with long-term guardianship. If you don't nominate guardians and you don't make it explicit, you don't make it legally documented, then a judge is going to need to decide where those kids are best placed. Who are those kids going to thrive with? Where are they going to flourish? And the judge is going to have to guess, because the judge isn't going to get to spend a lot of time with the kids. There's not going to be a lot of guidance for that judge to work from. It's going to be a difficult situation, but the judge is going to make the best decision that they can. And if that means sending the kids to live with Uncle Larry, then Uncle Larry is going to get the kids, even if you know Uncle Larry is the last person who should have the kids, right? So this is really important if you have minor kids, making sure that you get your guardianship nominations in place. Thank you again for answering the poll. All right. And then after you pass, how are people going to receive your assets? Well, there is a plan for that. If you haven't written an estate plan, then the state again has an estate plan written for you. And the estate plan that's written for you is a court process called probate. And probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. It's written there right on the slide. But that's what probate is. And probate is the process that your estate needs to go through if you don't have an estate plan in place. It's also the process that your estate needs to go through if you are relying on a will for your estate plan. And probate is expensive. You can see there are fees all over the place. There are attorney's fees, executor or personal representative fees, appraisal fees and filing fees. The creditors need to get paid, bond premiums. Probate is also slow. It is dreadfully slow in Minnesota. It takes a minimum of 6 to 12 months to get through the process. And oftentimes it's something more like 12 to 18 months. We'd like it to go faster, but we just can't get it to go faster. There are some built-in slowdowns in order to provide the creditors with enough time to come forward and make sure that they get paid. And so it is a pain, but it's a pain that, unfortunately, if you haven't written a plan in place, you are guaranteeing for the people that you love. But I talk about expensive. Probate costs in Minnesota an average of 3 to 6% of the gross value of the estate. And 3 to 6%, that doesn't sound bad. But if you can imagine, if all that you have is a house worth $400,000, you're already talking about probate fees in excess of $12,000. More often with just a single asset like that, it could even be higher because there are some baked in fees that you just can't reduce anyway. So probate is really expensive. We're going to have a moment here in just a little bit where we will actually get to calculate what probate might cost for you with some back of the envelope math as well. Probate's also public, and this seems totally crazy, but because probate is a court process, the court makes the information, opens the information up to the public. And so I'm showing you here, this is the last will of Anna Nicole Smith. And it's been a really long time since I've heard anything about her, but wills are totally public after you're gone. The public needs to be able to see them and needs to be able to examine them. And again, having a will doesn't avoid probate. Having a will means that you have to go through probate because the court has to read and interpret that will in order to know what needs to be done. And so this needs to be public. An inventory of your assets needs to be published, made public at the time that you pass, as well as distribution provisions and exactly who is going to receive your assets. And this is especially unnerving. I mean, there are predators out there, and we all know that. There are predators out there who are very interested in young people, in naive people receiving assets that maybe they're not ready to deal with or that they're not ready to handle. It's a sad fact in our world, but it is the way that it is. If you don't have a plan in place, your kids could be entitled to all of your assets outright and without any restriction at 18. And I think that we all kind of have in mind some nightmare stories that we've heard where somebody has received too much money at too young of an age, and it's really affected their ability to deal with their finances into the future. And maybe it's just completely spoiled them and completely spoiled their understanding of money and finances forever. I can tell you, I think I was a pretty mature 18-year-old. And in fact, there's somebody here, I think, that knew me at 18. But I can also tell you that if I had received a big inheritance when I was 18 years old, I would have gone out and I would have bought a Corvette and I would have driven as fast as I could. 18-year-old brain just can't handle it, just can't handle that kind of money. And so this is really important that you make sure that you protect your kids. And maybe it's not your kids that you're worried about, but if something happened to your child before something happened to you, or at the same time that something happened to you, then your grandchildren might receive. And if those grandkids are under 18, or even if they're 25 and still just have a little too much youth left in them, or not enough maturity in them yet, then this is something that you really want to attend to and make sure that you get taken care of. Okay, well, here is our opportunity to calculate our probate estate. And so I have here kind of an example probate or an example estate that we can do some back of the envelope math, like I say on. So here you can see there's a family home, there's a rental property. You can think maybe that's a cabin instead, furniture and household goods, and some automobiles, stock bonds and bank accounts. And there's also a business interest here. And so you can see everything added up, it totals $850,000. It's a pretty decent estate. They've taken care, they've put some money together. And you can calculate 5% of that gross estate really quickly. And that 5% falls in between the 3 to 6% that the average Minnesota probate costs. You can calculate it really quickly just by moving the comma over one place and then dividing the number in half. So 850,000, you move the comma over, 85,000, you divide that number in half, and that's how I got 42,500. I may have used a calculator, but this is another method of calculating that works really well. So here is a little added wrinkle. If you have minor kids and you have something like a life insurance policy or a retirement account, and you make that life insurance policy or retirement account payable to a minor, you include them as a beneficiary on that policy or on that account, then all of a sudden, those assets, because they're going to a minor, have to find another place to go. They can't go to somebody under the age of 18. Somebody under the age of 18 can't take and hold that property until they turn 18, and then they'll get everything. But if that's the case, where it's going to somebody who's under the age of 18, and a lot of times we just don't have another option. We want our kids to receive the assets, and they're young, and so if we haven't done planning and we haven't put together something like a trust that we'll talk about in just a minute, then that money is going to go to our kids. And it can be a really ugly situation because it needs to go through probate. It needs to go through conservatorship, and conservatorship is more expensive than probate. It is a real problem. But here you can see I've calculated 5% of this adjusted estate value based on adding these in. The reason that life insurance and retirement accounts generally don't have to go through probate is because they go by operation of law. By operation of law, they go to whoever the beneficiary is. And so that's something that's really important to know. Beneficiary designations operate outside of probate. They don't have to go through probate. But there is an absolutely foolproof way to avoid probate. And that way to avoid probate is by fully funding a living trust. And a trust is an agreement that is written by an attorney. It's an agreement written by an attorney between three parties, and you are each of those parties. So it's a little confusing, but stick with me here. You are the person signing as the creator of the trust. You're also the person signing as the person who agrees to take control of the trust and administer the trust in the way that it is written, based on the rules that are written in the agreement. And during your lifetime, you are also the beneficiary of the trust. You have all of the right to benefit from the assets that are put into the trust during your lifetime, okay? So you're the creator, you're the person with control, and you're the person who can benefit from the trust. You're in all three of those roles, all right? And by having executed this agreement and having you in all three of those roles, you can fund the trust, you can use the trust as you would. But the deal is, if you put everything into the trust, or you change your beneficiary designations to point to the trust, then when you pass away, the trust gets to decide who the next beneficiary is. The trust gets to name who the distributions are going to go to. And that's where you can name your kids to receive after you, or a charity, or whatever it is that you have in mind. You can put that into the trust and decide where your assets are going to go. But again, it is very important to fully fund that trust. And that means for different assets, it means different things. So if you have investment accounts, things like brokerage accounts, if you have mutual funds that you pay taxes on year after year, that sort of a thing, then you need to go to your investment bank and you need to retitle that investment account in the name of the trust. And for bank accounts, we all have bank accounts, or almost all of us have bank accounts. You need to go down to the bank and sign new signature cards so that those bank accounts are no longer in your personal name. They are in the name of your trust, which again, you are the creator of, you're the person with complete control over that trust, and you have the complete right to benefit from that trust during your lifetime. It also means executing deeds to real property so that you're actually taking your home and you are changing the name on the deed. So it no longer says your name, but it says your name as trustee of your trust. You're actually taking that home and putting it into the trust by executing that deed. It also means transferring stock and bond certificates that you have so that those are named into the trust, so that they're titled in the name of the trust. assigning personal property, and this is a really easy thing to do. It doesn't mean that you have to go around tagging every item of furniture and clothing in your house. There's just one document that you fill out called either an assignment of personal property or a bill of sale. And just by filling out this one document, you can put all of your personal property, things like furniture, clothes, jewelry, you can put all of that into the trust very easily. And then changing life insurance and retirement account beneficiary designations so that they ultimately go into the trust, and the trust gets to dictate how those assets are distributed out. And obviously with a life insurance policy, that's not active until you die, or you don't have the proceeds until you die. But when you die, you want to make sure that those assets are in your trust so that the rules that you've written into your trust about what should happen after you die, your trustee, your successor trustee, can step into your shoes as the person with control and can follow the instructions that you've written to make sure that the successor beneficiary, the beneficiary that you've named to come after you, will receive those assets. Retirement accounts, for tax purposes, we generally have them go to the spouse first, and then they go into the trust. And we write special rules into the trust to deal with those in case something comes up and a special needs or a supplemental needs trust is needed, in case there's a child who needs extra help and extra support and might be receiving support from the government for things like food or for their housing. If that's the case, we want to make sure that that child isn't directly receiving an inheritance, and that's why we have things go through the trust. And we make sure that they get the best tax treatment through the trust as well. I'm not seeing a lot of questions. I don't know if any questions are coming up for people, but again, if you look, you should be able to find the chat and the Q&A box and ask your questions if you have them here. Okay, good news. The good news that I have to give you, estate taxes. So this is somebody saying I'm doing great. Hey, thank you very much. Good. This is how we can calculate what your estate tax might be. And the good news that I have to tell you is that the federal and the Minnesota estate tax exemption is really high. On the federal level, it's incredibly high. It's $12.06 million this year, which means for your first $12.06 million, you pay nothing in estate taxes, or your estate pays nothing in estate tax after you're gone. And even better news, if you're married, you get to double this number. So it's actually $24.12 million is the amount that gets to pass on to the next generation without any federal estate taxes coming out. Now, the federal estate taxes are steep. They go up to 40%. So the 40 cents on the dollar once you get above that 24 million or $12 million number. But again, it's not a number that applies to most people. In Minnesota, we have a lower exemption. It still doesn't apply to most people. This isn't why most people do estate planning, but it's something that's important to know is that this either might apply to you now or it might apply to you in the future. That the Minnesota estate tax exemption is only $3 million. And unfortunately, in Minnesota, we don't get to automatically double that number, in the same way that they do on the federal level. You can double that number by doing some planning in your estate planning documents. There's something called a disclaimer that you can make. It's extremely complicated, but that's why you come to an estate planning attorney who can handle this kind of thing and can make sure that those provisions are written in so that you get the best estate tax treatment when you pass, and that your heirs are able to receive as much as possible. And I see somebody saying, what does it cost to set up a trust? And I promise you, I am going to get to that question. I'm going to get to that question very soon. I'm sorry to put you off just a little bit, but I promise you that I will give you an exact number that it costs to set up a trust in just a little bit. Does anyone have any idea how much money is currently in our State Department of Unclaimed Property? And you're going to have to erase me here because I'm going to click over $700 million right now is in the Minnesota Department of Unclaimed Property, $700 million. And across the United States, that number is something like $58 billion in the state departments of unclaimed property. And the way that that money gets there, in large part, is that somebody passes away and the people who come after them, their family, their heirs, their friends, whoever is going out and trying to collect all of their assets, misses something. And maybe they miss some stock certificates, or maybe they miss some dividends that the person was supposed to have received and never cashed the check. Or maybe they miss a bank account that most of their banking was done at, bank A, but they did have some accounts over at bank B where they were trying to save some money for a new cabin or something like that. And all of a sudden, this account or this stock or whatever it is just gets missed. And when it's missed for long enough, all of a sudden, it ends up rolling into this Department of Unclaimed Property, where it ends up sitting, and it can end up sitting for years and years. And so that's something to be very aware of, is that you need to make sure that your assets are inventoried. And that's something that I do as an estate planning attorney, but most estate planning attorneys don't take care of and don't touch. They don't think that that's part of the estate planning realm. But I can tell you, as, again, a father of 3 minor kids who is still building the wealth that I want to give to my kids, I want to make sure every dime that I have goes to them, and that every dime that I have is able to pay for their education and is able to pay for their upbringing. And so it's really important to me that nothing of mine be lost to the Minnesota Department of Unclaimed Property. Okay, this is really cool. You can actually make your estate plan, you can make your trust a real treasure chest for your kids by building in something called asset protection. And asset protection means that their inheritance can be protected so that it's never taken away by a spouse in a divorce, or even touched if your child is in a car accident or sued at some point in the future. You can build in these lifetime asset protection trusts that are really neat to have and can provide some real airtight asset protection for the money that you leave behind. And the reality is that's an inheritance that you want them to have and that you want them to enjoy. And you don't want that money ending up being commingled into a joint checking account just before a divorce happens or something like that, where that divorcing spouse can end up receiving a whole bunch of the inheritance that you had really hoped was going to go to your child and they were going to enjoy. I see another question coming in. In the case of a married couple and one dies, do assets such as the house still go through probate if both are on the deed? That's a fantastic question. Thank you for asking it. If you own property jointly, if you own property in joint tenancy, or just jointly in general. With real property, you might own it in joint tenancy. You might see that on your deed. Then by operation of law, it's kind of like a beneficiary designation. By operation of law, it just goes immediately to the surviving spouse. And that surviving spouse is then the only person holding title to that asset. Now, generally, there needs to be some cleanup work done on the deed. There needs to be some cleanup work where you file something called an affidavit of survivorship and identity. And you file that with the recorder to let them know that one of the spouses has passed away and now title is only held in one spouse's name. But that is a really fantastic question. And it means that probate does not generally need to happen after the first spouse passes away. Most spouses hold, their big account, their big checking account or whatever it is held jointly. And that operates the same way, that by law, if you're holding an account jointly, when you pass away, whoever that joint owner is, whoever that other joint owner is, they become the sole owner of that account. And then it's the same with the house, that generally spouses will own the house as joint tenants. So that's the deal with that. So that's a really fantastic question. I thank you for bringing that to me. All right. So I know that this is a difficult topic to talk about right now with everything that's going on, but it's something that is really important to talk about incapacity and to talk about what your healthcare wishes are and who you would want to have as an advocate on your behalf telling people what your healthcare wishes are. And so the person that's pictured here is Terry Schiavo. And I'm sure many of us remember Terry's case from the mid 2000s that Terry suffered a heart attack, and she ended up in a vegetative state. And her husband and her parents were fighting over what should happen to Terry. And her parents thought that Terry would want to be kept alive if there was any hope, if there was any chance of her interacting with the world, that Terry would want to stay alive and be kept alive with a feeding tube and with ventilation if needed, in order to experience that chance at life. Her husband didn't think that Terry would want to live in this vegetative state that she was in. And her husband wanted to pull the plug, wanted to let Terry go. And so there were court cases that came out of Florida, but ended up going all the way up to the Supreme Court. And there was a lot of court and a lot of conflict for that family, but also for all of us across the United States that were watching Terry's case and were watching what was happening. And so it is very important to not only plan for when you're gone, but to plan for this possibility of being incapacitated, and to make sure that there are people in place who can make healthcare decisions for you, who can make financial decisions for you. And the documents that help people to do that, or that give people the legal right to do that, are called a healthcare directive and a power of attorney. And they are definitely a part of any well-drafted estate plan. All right. So I've talked about a lot of things today. I've talked about probate. I've talked about guardianship. I've talked about the Minnesota Department of Unclaimed Property and how they end up with so much money. I've talked about estate taxes, and luckily that doesn't apply to most of us, but I've talked about incapacity, and that can really be a nightmare situation where you want somebody to be able to make decisions for you, or you would want somebody to be able to make decisions for you, and you can no longer express your wishes to make that happen. I've talked about a lot of things, and you're probably thinking, what can you do today to do the right thing for your family, and what should it cost to plan right? And so really your options when you're creating a plan are to either do it yourself or to work with a lawyer. Do keep in mind, not all lawyers are the same. So how do you choose? Would you benefit from working with an attorney? And there are some instances where I just strongly encourage you to consider working with an attorney. Obviously, I'm biased. I'm a lawyer. I'm an estate planning lawyer. This is what I do to make a living. But at the same time, there are some things that are just so detailed and so nuanced that that you really want to make sure are taken care of by somebody who has experience in the field. So there are times when you don't need a lawyer. And if you own nothing more than your personal belongings, if you just have a car and clothing and jewelry and furnishings, and that's about all that you have to your name, if your assets don't total up to more than $75,000 and you don't have any real estate to your name, then you could probably take care of your estate planning yourself. There's actually an abbreviated form that you don't have to go through probate, but you can use something called an affidavit for collection of personal property. And so I've made this recommendation to people when they have assets that are at a lower level, and we've still figured out if they need incapacity documents and that kind of thing. But generally, if you're above that level, if you own your home, if you have assets that are in excess of $75,000, I mean that, whether it's bank accounts or retirement accounts or investment accounts, wherever that money might be, if it totals something more than $75,000, you would probably benefit from working with an attorney. If you want to ensure that the people that you love stay out of court and conflict and have somebody to turn to when something happens to you, then you've got to work with an attorney. You've got to have an attorney whose name you can give them that they can turn to. If you want a kids protection plan, which includes the short-term guardianship nomination, long-term guardianship nomination, as well as medical powers of attorney for the kids, instructions to caregivers, instructions to guardians, and a whole lot more, then you have to work with an attorney. And if you want to avoid probate or estate taxes, or you want to protect your children's inheritance using asset protection, then you have to work with an attorney. Those are things that only an attorney can draft and only an attorney can do. And if you want to guarantee that your plan is going to work when your family needs it to work, then you really have to work with someone who's an expert, who's done it before. And I tell this story. It's embarrassing for me, but maybe you'll get a laugh out of it. My son, I wanted to take my son fishing, and we had just gotten a couple of new fishing rods and reels, and I was trying to put fishing line on my new reel that we were going to take out later that morning to go fishing. And so I was there down in the basement, and I was winding the reel, or winding the fishing line on. And I don't know if I had it coming off of the spool the wrong way. I still am not exactly sure how I managed this. But as soon as I snipped the fishing line just came jumping off of my reel, and it was everywhere, and it was a tangled mess, and it was a real problem. Now, that's okay, right? The risks involved with putting fishing line on your reel are pretty low unless you really epically make a mistake with the fishing line. And I didn't epically make a mistake. I made a mistake, and I lost some fishing line. But the only risk that I had involved was maybe 25 cents worth of fishing line or something like that. It wasn't that big of a deal, right? And I knew immediately, trust me, immediately, that I had screwed up the way that I had put this on the reel. I knew it immediately. That's just not the case with estate planning. With estate planning, the risks are huge. You could subject your heirs, you could subject the people that you love to probate, to a court case that's going to take a whole bunch of the assets that you want to give them, and is going to take a whole bunch of their time and attention and focus, and is going to cause conflict during a time when they should just have the space to grieve you. It's a huge risk to try estate planning on your own. It just is. That's just the nature of estate planning. And also, it's not cheap. It's just not. If you mess up something with estate taxes, it can be very costly to the people that you love. You're also not going to know. If you are trying to do it yourself with an estate plan, you aren't going to know immediately if the estate plan that you've written is going to work or is going to fail when it really needs to work. And there's just no way to really be able to tell that. When an estate planning attorney works on it, they know that this estate plan is going to take care of you. It's going to take care of the people that you love when you need it to work the most. This is just one added provision. If you want to give your assets to someone other than your kids, if you want a friend to receive, if you don't have kids and you want the assets to go to charity or nieces and nephews or somebody else, then you really want to work with an estate planning attorney who can make sure that the assets get to the right place. And I see another question coming in. Does probate occur no matter the amount of the estate? And no, there is a lower threshold for probate, and that amount is $75,000 as long as there's no real estate. If there's real estate, it has to go through probate. But if there's less than $75,000, then that is the lower threshold for probate. And there's another process that you can use called an affidavit for collection of personal property. I see here what happens with the house if you want to move, sell, and buy a new house if it's in a trust. And again, that's another fantastic question. Because you are the creator of the trust, you're the person with complete control over the trust, and because you're the beneficiary of the trust, you can sell that house no problem, and you can take the proceeds yourself, or you can put them into something like a bank account that's already held in the name of the trust. That's no problem because you have the complete ability to benefit from your trust, and because you have complete control over your trust, you're not going to have any problem doing that. Good question. So now you probably know whether you want to work with an attorney, but now you need to know, how do you choose that attorney that you're going to work with? And I want to bring us back to this quote, which again, was not said about me, but this was my parents' experience working with an estate planning attorney who's practicing in a very traditional, in a very typical estate planning model. They felt like this attorney must have graduated at the bottom of the class, but really what they were probably frustrated with is the model that this estate planning attorney was using. And again, I call it planning for death. Planning for death, this is the typical experience that you have working with an estate planning attorney. You're going to get form documents that just seem like kind of set it and forget it documents that they will fill in your name here and there, but they're not going to do a lot of customization. They're not going to do a lot of tailoring in those documents to make sure that everything is perfect for you and for your family. Typical experience doesn't keep the money out of the Minnesota Department of Unclaimed Property. It may avoid probate, but it may not. There's just not a lot of estate planning attorneys, in fact, plan for probate because probate is kind of lucrative. That if they can have a plan that they're able to write now and that ends up needing to go through probate, they can collect a fee for writing that plan now. And even if they collect a lower fee because they're just writing a will for you or something like that, then they can go ahead and collect the fee for the probate in the future when something happens to you. It's ugly, and I hope that that's not the case. I think more often lawyers get discouraged because they don't have enough time and attention to make sure that trusts get properly funded. But it's a fact of life that a lot of estate planning attorneys that this happens, that they end up doing a lot of probate for the people that they wrote estate plans for when they were younger. All right. Typical experience probably isn't going to keep your family out of court in conflict. Typical experience is only going to focus on the money. It doesn't focus on things like stories and values and sharing those intangible assets with the people that you love. And the typical experience is going to leave assets to heirs unprotected. Without that asset protection, most estate planning attorneys just don't build that in under the typical model. The typical experience doesn't have ongoing legal guidance. Generally, hourly fees are charged for future needs. And that means that you're going to be really reluctant to pick up the phone and tell your attorney that something has changed, or ask if something matters, if this matters, if this has changed, or even ask, what is the name of my trust again? Or what is the name of your law firm? Anything that typically it ends up with a bill in the mail, an invoice for picking up the phone and calling your attorney's office, which I think is totally out of control. Typical experience also isn't going to adequately protect kids. That oftentimes they include that long-term guardianship, somebody to raise the kids until they're 18, but not those documents that are so necessary in order to protect the kids in the immediate and short term. And really, you're going to be left with this question: is this going to work when I need it to work? And that's not a question anybody should have about their estate. Everybody should have clarity and should have certainty about what is going to happen in their estate after they're gone. And that's why I have devised an entirely different way of planning. I still write estate planning documents. I write really good estate planning documents, don't get me wrong, but it's about the experience, and it's about making sure that the experience is good for you and that you are educated and empowered the entire way so that you're making the decisions and I'm just documenting those decisions and making sure that it's what is going to happen legally. So planning with me, I charge flat fees and I let my clients choose the fee. And that doesn't mean that I rely on your goodwill in order to put food on my table, but I have some fee packages that I will talk about in just a minute. I know that was somebody's question. I promise you I'm getting there. I have some fee packages, and I want when we work together, I want you to choose the package that's going to work best for you and the best for your family. Planning with me means keeping your money out of the hands of the state, keeping it out of the Minnesota Department of Unclaimed Property, keeping it out of having to pay for estate taxes as much as possible. I'm really passionate about those things, and it seems really important to me that your heirs are able to receive, not the state of Minnesota. Planning with me means protecting your kids totally in the immediate term and in the long term. It means keeping your family out of court and conflict. And I got to tell you, this is really near and dear to my heart. This is what got me into estate planning is avoiding conflict in families. And I really see myself as a peacemaker. And that's an opportunity that you have when you're planning now, is you can really be a peacemaker for the future, and make sure that your family is able to avoid unnecessary conflict over the assets and over what mom or dad really wanted to have happen. Planning with me, it means knowing that you've made the right decisions, because I'm not going to make those decisions for you. I'm going to empower you and educate you so that you have all the information you need to make those decisions. Planning with me means protecting the family money from outsiders, having that asset protection on the money so that it is completely protected and your heirs are able to enjoy the inheritance that you want them to enjoy. Planning with me means a lifetime of guidance and protection, because I'm not going to charge you hourly fees in the future for just picking up the phone and telling me that your first grandchild has been born, or telling me that you sold the house and is there anything that you need to do before you buy the new house. Just pick up the phone. I want to hear from you. I want to have a relationship with you, and I want to, if possible, have know your family a little bit, because when something happens to you, they're going to need somebody to turn to. And I want to be a friendly face that can help them out and make sure that everything gets taken care of the way that it needs to be taken care of. Planning with me means that you're going to know that your plan is going to work when your family needs it to work. And again, this is really a gift that you're giving to the people that you love the most. Here it is. Here's the slide. We're going to talk about what exactly should estate planning cost. What does it cost in a typical estate plan with a typical death plan attorney? And what does estate planning cost when you work with somebody like me, who works in really a completely different way? And so just to set some context, if all that you have is a house worth $400,000, and I completely recognize that's a very nice house. If I would have said this 5 years ago, everybody would have rolled their eyes. Who's got a $400,000 house? Nowadays, it's almost everywhere. Housing prices have raised, and that has driven up prices of a lot of other things. But if all that you have is a house that's worth $400,000, and tailor this to what your house is, you'll save your family at least $12,000 getting an estate plan in place that avoids probate. And if you have assets over $3 million here in the state of Minnesota with the estate tax exemption at $3 million, then this planning is going to save your family at least 13 cents on the dollar for every dollar in excess of $3 million, making sure that we're able to plan for it. We're able to pay as little estate tax as possible. And I can tell you, because I've seen it, the typical death plan with a lawyer is going to cost at least $1,500. And you can almost guarantee it's not going to keep your family out of court and conflict. It's not going to ensure that your assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your money. It's not going to cover your intangible assets. It's not going to cover your kids' immediate care, nor share your values, insights, stories, and experience, those valuable, intangible, and often lost assets. Or you can meet with me and you can plan with me. I'm a personal family lawyer, and that means I practice in a very special and very particular way. I believe in working really closely and spending a lot of time and giving a lot of attention to my clients. And you can learn exactly what your family needs. And you can, again, choose your own fee with a range somewhere between $2,000 and $8,000. And you're going to know that your plan is going to work when your family needs it to work. And so that answers the question, what does it cost? Well, it doesn't specifically answer what does it cost to set up a trust. I can tell you, writing a trust with me starts at about $4,000, and that's where most people end up. That's what fits most people, is operating exactly in that range at about $4,000 is generally what the cost is. But I want to make it easy and I want to make it affordable for you. And so I have a couple of giveaways here. The first thing that I want to give away is 2 hours with me. I want to give you a free 2-hour meeting called a family wealth planning session with me, which has a $750 value because of the amount of time that it takes for me to prep for the meeting and to meet with you. But just for attending today, by doing the right thing here today and being here with me and planning for your family, I want to give you this gift of a free 2-hour long meeting with me. And in that meeting, the first half is where I educate you and empower you, and we talk through your situation, and we talk through what would happen right now if something happened to you. What would happen if you became incapacitated? What does that look like? What are the court cases that your family would have to go through in order to get the ability to make financial decisions for you? And what would your family have to go through to make healthcare decisions for you? And what would those healthcare decisions look like? And if you passed away, what would probate look like for your family right now? Do you owe estate taxes? Who would step up and be the personal representative for the probate court? Who would the court appoint? What's most likely? What is it going to cost you? How long is it going to take? We're going to talk about all of these questions just in the first hour. And if you want to plan with me, if you want to go ahead and have me write an estate plan and complete an estate plan for you, then I want to give you $250 off of that estate planning package of your choice. And that's what the second part of that family wealth planning session is where we actually design that plan together. And I'll walk through it with you. I'll even diagram it out because it's really helpful to see exactly what these things look like. I'll diagram out your trust, or if you would benefit more from having a will and some other estate planning. It's something that we discuss in the family wealth planning session, but I'll diagram it out for you. I'll make sure that you completely understand the plan that we've built together before we move forward. That's really important. And so I want to give this to you. I want to give you a free family wealth planning session, and I've gone ahead and put my booking link into the chat. Hopefully everybody can see it. You can click onto that link and you can click onto family wealth planning session, and you can see my availability coming up in the next few months. I can tell you, I don't have anything left in January, of course, and it's starting to look kind of sparse for February. It's even looking a little sparse for March already. But I hope that you will click through, take a look at my calendar, and find a time where you can meet with me and where I can answer your questions. And I see somebody saying, we're already booked for February. Fantastic. I'm glad that you got in, and I'm glad that you found a spot there. I see somebody raising their hand as well. One of the participants raising their hand. And I don't know if you want to be allowed to talk. That's kind of daunting for most people. So if you can put your question in either the chat or the Q&A, I'll make sure to look at it there. Great. And I see somebody else is, yes. Yep. I see somebody has booked for next week. I'm really looking forward to that meeting as well. It's going to be a great meeting that we're going to have together. Now is a great time to ask questions. And in fact, there are some questions that I promised that I would talk about today when I went through and called some of the people that are here with us today. One of those questions is talking about nursing home care and talking about what that looks like and where the money goes when you're in a nursing home type situation. It is really scary right now because nursing home care is very expensive, and the assets that we've accumulated over our life and that maybe we had intended to pass down to the people that we love often don't stand up to those nursing home care, those assisted living care costs. And so sometimes we are looking to the government for some support, for some help in paying those nursing home costs. But what the government expects from us, the government expects us to impoverish the other assets that we have, or impoverish ourselves and distribute out all of the assets that we have in paying for nursing home care costs and in paying for medical care costs before they will step in and help us to pay for those costs. There are some things that we can do to plan around that. Sometimes it's advantageous to keep the house and have that be a store of value, because a house is excluded as an asset for consideration when considering what assets you own for certain government benefits. There's a lot of nuance that goes into it. So I just want to say, if this is a concern that you have, if you have a concern about nursing home care costs, and they are very steep nationwide right now, if that's something that's real for you, I hope that you'll reach out to me, because it's an area where I help people out frequently. Medicaid planning and asset protection planning is something that I help a lot of people with. Elder law is another name for it. So if that's something that you're concerned about, please do reach out to me. I have somebody saying, what if you already have a will, power of attorney, healthcare, advanced healthcare directive done with a firm like Legal Shield? Could that be taken into consideration in terms of cost? It's a very good question, and I really appreciate you raising it here. It often will not affect the cost of the planning that we do together, because oftentimes in the planning that we do together, it makes sense to create a new will, a new healthcare directive, and a new power of attorney. I'm not going to say an absolute no. I hope that you'll reach out to me and that you'll schedule a meeting with me, and we can review those documents and see if those documents are doing what you want them to do. If you're okay with the way that they're written, and if you're okay with the things that they provide, then we can talk about how that might affect the price of the package that you choose. But really, it usually makes sense to do estate planning all together. And I can tell you, with a will, oftentimes if I'm writing a trust for somebody, the will that we're writing is unlike the will that you would have from an online will or from something like Legal Shield. And the reason for that is it's a specialized kind of will that gives the assets over to your trust in case you don't fund that trust completely during your lifetime. Something called a pour over will. And there's a lot of nuance and a lot of particulars about that. But again, I hope that you'll reach out to me. I hope that you'll book a meeting with me. We can review that will, we can review that power of attorney and healthcare directive, and talk about those things and talk about what makes sense and what needs to be done. Again, this is a great time to ask questions. If you have more questions, I love that we've got some meetings coming up with people. I'm glad that they're here to learn and educate themselves ahead of the meeting. It's fantastic. Supplemental needs trust or special needs trust are something that is really important to know about, and it might affect you, it might affect somebody that you love. But if somebody is receiving government benefits and they are the recipient of an inheritance, it can knock that person off of the government benefit that they're receiving. And so that might not sound that bad, because now they have an inheritance that they can use. They have an inheritance that can pay for their rent or that can pay for their food. And that's true. But the problem is that not only do we want that person to enjoy the inheritance for things other than their most basic needs, but the added problem is that it takes time after you get knocked off of a government benefit to reapply and get back on that government benefit. And so there can be some gap months where there isn't coverage. The inheritance isn't covering, the government benefit is still processing, or the application is still processing, and the person is left with needs that just can't be met. And so there's something called a supplemental needs trust, which is a special kind of trust. It's not a revocable trust or a living trust like I was talking about tonight, but it's something called an irrevocable trust or irrevocable. And it takes those assets and holds those assets only to distribute them out to that person with special needs or who is receiving those government benefits in a way where it's not reimbursing them for things like rent, it's not reimbursing them for things like food. And by restricting what they can take money out of the trust for, they are able to stay on that government benefit without interruption. It's really important. It's really important if you know somebody who has kids that have special needs, it is just something that I have seen that's been missed and can cause a lot of hurt when somebody receives inheritance, which sounds like the exact opposite of what most people would want to have happen. I'm not seeing any other questions coming in, and so I think I'm probably going to wrap it up here. My voice is already getting a little ginger after talking to you for this time. Oh, I do see so somebody saying thank you so much, so informative. You're very welcome. I'm also saying I'm power of attorney for my 84-year-old mother, and I'm trying to get her affairs in order. I have her on a list for assisted living, and I'm wondering if I could still get an estate plan in order before she goes in, or is it too late in the game? That is a really fantastic question. I'm glad that you brought that to me. Oftentimes, it still can be done. You still can get an estate plan in place. If your question is surrounding the competency or the capacity that your mother has in order to complete an estate plan, that's something that we can evaluate together and that we can talk about together. The capacity that you need to have to sign something like a will what it is they need to have knowledge of the assets that you're talking about, not specifically, but they have to understand that these are my things, and that by executing this document, I am giving them to this person. And so if it's a situation where you're not sure that they have the capacity to do it, sometimes there are situations where in the afternoon, the person just doesn't have the capacity anymore. They're just struggling too much. They're struggling too much to remember names and faces. And it's clear that they just don't have the capacity to do an estate plan. But I have seen times where if you go in at the right time, if you go in at 9 o'clock in the morning or whatever the time is for this person, it's just the right time, and they're lucid and they are able to understand what you're talking about, at least to a level where they're able to create an estate plan. So if that's your question, if it's a question about capacity, it's a really difficult thing to evaluate based on a fact pattern in chat, but I would be very happy to discuss with you in more detail and to make an evaluation of whether or not they have capacity to do it. If your question is, are we too late in the game to do planning because we're going into assisted living and now we're just going to have to spend all of our money on assisted living, then it is never too late. It truly is never too late. I've had clients who are in a nursing home and we're able to do some planning so that all of their money doesn't have to go to that nursing home, but they're able to qualify for a government benefit to help them out, to help pay for that nursing home situation. And they're able to give part of the money as an inheritance to the people that they wanted to receive that money. So it's never too late in order to do that planning. It is more difficult the later that you do the planning, of course, but it is never too late until somebody is gone to do that kind of planning. So great question. All right. Well, I really appreciate everybody joining me here tonight. It has been fantastic getting to answer your questions, and it's been fantastic getting to educate you. I'm so passionate about this. I hope I'm sure that that's come through painfully clearly. But I really hope that you'll book a meeting with me and that we can meet one-on-one. My meetings almost all are virtual right now. I do travel to clients from time to time when they have needs, when they have the need to meet in person. And I know sometimes it just is a need. You need to be able to see my lips moving, or you need to be able to sit in the same room as me. I completely understand that. But we can meet virtually. And there's a little bit of homework that I'm going to have you complete ahead of our meeting, but I promise it's not too bad. And it's just going to get you organized. It's just going to get you more organized maybe than you've ever been around your finances before. It's really a positive thing. So I look forward to meeting with you. I look forward to helping you take the next step on your estate planning journey. And I look forward to helping you get things in place for the people that you love so that things are taken care of. And it's not something that you have to fear, that you have to worry about what is going to happen when something happens to me. So have a great night, everybody. Thank you so much. And I look forward to talking with you.